my understanding is that in this tribunal, often the practice has been for documents and for material which is on the 65-ter list to be referred to during the course of the opening, because Your Honours, of course, are professional judges that are well able to take away from your minds such things that may or may not in due course be ruled to be admissible. And for that reason, these documents and documents like it are normally permitted to be opened during the course of the opening, and in due course, if there are any other matters which need to be removed, then they are removed at the stage at which the evidence is litigated. Your Honours, much of the evidence in this case is hotly contested, and there are a large number of outstanding applications relating to admissibility of evidence at a very early stage of the proceedings. And none of those have yet been decided. So, Your Honours, my submission is that Your Honours should hear the opening. It may assist Your Honours to determine admissibility in any event, to hear what the relevance and the context of the documents are, and then to, in any event, to adjudicate in due course. Because we say that the material that I'm putting before Your Honours is highly relevant, and that the authenticity of the document can be established, and we can litigate whether or not it was admitted in the last trial. But my recollection is that it was.
I'm so sorry. It's really worrying when a prosecutor stands up to make an opening submission in which, according to this document, he has no less than 5 separate extracts of this book, and he doesn't even know, despite the fact that we've pleaded it in our opening brief, that this document was excluded on grounds of having no probative weight. That is a staggering state of affairs, frankly, for a man opening a case for prosecution.
Can I just make a few comments? First of all, I just want to say that I accept that the chamber is composed of professional judges who are able to disabuse their minds of things that are irrelevant. However, it is also constituted of human beings, and you will realize that in the guidelines that have been given, the whole question of MFIing documents is being forbidden precisely for that reason. If you're going to get one document, you may be able to disabuse your mind of its contents. But if I'm going to get 150 of them, it becomes pretty difficult, humanly impossible to do so. And therefore, this chamber intends to keep to a very bare minimum any documents that come in which may later have to be thrown out. May I finish my comments?
Forgive me, yes.
I just want to reiterate what the chamber mentioned yesterday. This is a new trial, and anything that has to be proved here must be proved here. The arguments that things were proved in the previous trial do not make any sense at all. And reference to the fact that things were thrown out, therefore they must be thrown out here, doesn't make any sense. I would like, will you please let me finish, Mr. Emerson? Anything that is objectionable must be objected to here, and the ruling will be made here. And the ruling of this chamber is not going to be dependent on whether the ruling of the previous chamber was consistent with our ruling. I just want to make that quite clear to all the parties right at the beginning.
Well, we have, I hope, A, entirely understood that, and B,
but you don't behave like
well, can I just be absolutely clear on what we do understand the position to be? The ruling of the appeals chamber indicates that whilst the prosecution is not precluded from seeking the admission of evidence that was excluded in the previous trial, the fact that it was excluded in the previous trial will be a material consideration for the new retrial chamber in determining whether its admission is justified according to different standards of relevance. That is the test that the appeals chamber laid down in its most recent ruling. It therefore cannot simply be said that the previous trial rulings are irrelevant. What is most troubling is that there is a basic minimum professional duty on prosecution counsel to acquaint themselves with what is the factual position on a document they are seeking to rely upon. I'm assuming that Mr. Rogers did not intentionally intend to mislead the trial chamber, but there can be no question but that he is aware because it says so in our opening brief. A, that objection is taken to the admission of this document, and B, that it was excluded by the previous trial chamber on the grounds that it was probatively rubbish, if I can paraphrase. We'll provide your honours with the ruling. Your honours will want to consider that ruling in accordance with the appeals chamber's judgment to determine whether the prosecution has laid down some different evidential foundation justifying a different approach. But otherwise we'd have two trial chambers reaching opposite conclusions on precisely the same legal and factual material.
And that happens every day?
Well, it can happen, but no trial chamber would want to do that without first acquainting itself, as the appeals chamber indicated, with the course of the proceedings before. But be that as it may, for Mr. Rogers to stand up and put it forward to your honours on the basis, A, that there was no objection in the previous trial, and B, that the matter document was not excluded, it indicates at best a significant lapse of professional standards, and leads me to a more general concern. Your honours will see in this bundle at page 22 another map, hand-drawn. This map, this is the bundle of exhibits that the prosecution proposes to put before you in opening. This map was drawn by Shefchet Kabashi as a part of his witness statement. Now that witness is due to testify tomorrow, and as Mr. Rogers well knows, there are very serious reasons to doubt whether he will in fact do so. So for him to seek to introduce before your honours, as though it were evidence, what is in effect part of the statement of a witness who he knows he may be unable to call.
May I interrupt you, Mr. Emerson? This is not the time for the defense to argue its case or to make a statement. We are on an objection of one book, and I'm not looking at that map that you have just shown to me.
Right.
We are on the objection of the book that Mr. Rogers is about to talk about which you stood up to object.
Yes.
Just give me a chance. You stood up. I said to Mr. Rogers, can I make a few remarks? And you stood up before I made my last remark, which was going to be a repetition of what I'd said a little earlier to Mr. Rogers. And I think what you are doing, you are going over and over again, same issue, using different exhibits. And if you can just listen to what I'm saying and let the chamber make a ruling on what Mr. Rogers is about to do.
I'm entirely in your honour's hands.
Thank you so much. Mr. Rogers, I remind you, the last comment I wanted to make, I think it is important, therefore, where there is a dispute between the parties about the admissibility of a document, that it be admitted in the normal course. I do not agree with you that the chamber can read the document to determine its admissibility. Admissibility is determined before the document is tendered, and only on being admitted may it be published to the chamber.
Your Honours, I understand that, but it's quite normal to put before the court, I believe, documents that the prosecution intends to rely upon during the course of the trial as part of the prosecution's opening. And often there is contests about the admissibility of those documents and the weight or whatever that may be attached to them. Your Honours, I must take up Mr. Emerson, because he's made a number of very serious allegations against me personally. Your Honours, I entirely agree with him that it is incumbent upon counsel to check their facts. And I did check my facts. And I have in front of me an email sent by Mr. Emerson and Mr. Dixon on the 9th of January 2007 in the course of the last trial, dealing specifically with the book that I'm referring your honours to, in which they state it is admitted by the defence for Ramush Haradinaj that the book entitled Story of War and Freedom, from which I am quoting, was compiled from a series of interviews with Mr. Haradinaj by Bard Hamzai. There is no dispute as to the authenticity or admissibility of the book in its entirety. How or why the trial chamber failed to admit it in the last occasion, I don't know, but they did and they took their own decision for their own reasons. But that's my understanding of the position last time.
It is simply just for the sake of the record, that is simply wrong. There was no agreed fact to that effect, and if Mr.
Rogers has not alleged an agreed fact. He alleged an email coming from you, Mr.
It's absolutely clear that objection was taken during the trial, and the decision on the prosecution's motion to tender documents on its Rule 65 TER exhibit list of the 30th of November 2007 at paragraphs 6 to 7 excluded that document on the grounds that it lacked any probative weight.
I agree it was excluded. It's a remarkable decision in the context of what was admitted by the defence and the clear relevance and probative value of what the defendant himself has to say about the organisation of this zone, the relationship between himself and his uncle Lahi Brahimai and others who are also subject to this indictment. And, Your Honour, respectfully, to try to rule it out at this stage of the proceedings would be wrong. Your Honour should hear what it has to say, especially in the light of the fact there appears to be no objection to authenticity. Whatever the arguments may have been that were taken up last time round, I'm surprised my learned friend is reverting to arguing that it should not be admitted, given the clear statement that it's authentic.
I see you, Mr. Guysmith, but I just want to say this to you, Mr. Rogers. The Chamber is not saying you may not tender that document. The Chamber is saying you've got to tender it and prove its admissibility before you tender it. The practice of not just referring to a document that will be used, but actually wanting to give the content of that document in opening undermines the whole process of admissibility of evidence into the record. And this trial chamber, I would imagine, would allow you to make reference to the document, that book, to say that it will be used. And at the appropriate time, when you do have a witness through whom you can tender the document, do so. That we will hear that later doesn't make any difference from hearing it now. The only difference is that you want us to hear it now before it's an exhibit. That's my problem. And you are welcome to say you will be tendering a document or a book that is going to tell us what you think the trial chamber should know about Mr. Haradinaj. But not try to tender it now.
I can deal with it in that way.
Thank you so much.
In which case, Your Honours, in that case, I'll deal with it like this.
In deference to Mr. Guysmith.
Thank you, Your Honor. I believe that the colloquy that you just had with Mr. Roger takes care of my point. I was going to suggest we're dealing with opening statements and not with arguments about the admissibility of evidence at this point.
Thank you very much.
Your Honours, can I deal with it like this? During the course of the trial, the prosecution will produce to you a document in which the prosecution says the accused, Ramesh Haradinaj, indicated that he was one of the first persons in the Dukajin group, along with Lahi Brahimai, his uncle, and that together he and Lahi and his other relatives, they established the first Dukajini group of the KLA. He also speaks, we say, of his return to Kosovo from Albania. And the prosecution suggests that when he first returned, he went to Jablanica, where he spent days checking equipment, and that he accepted individuals into the organisation of the KLA. And those people included Lahi Brahimai, Shkelzen Haradinaj, and Luan Haradinaj. There was then a period of time when he continued his activities outside of Kosovo between 1994 and 1998, and then returned to Kosovo. to where we suggest he had created the first base, and a base he had assisted in developing in Jablanica. And he developed his network. The document we suggest says that he helped create the network in the Dukagin area and worked in close cooperation with his brother Dot, Shkelzen Haradinaj, and Lahi Brahimai, also known as Maxhub. Your Honours, when the Haradinaj family compound in Glojan was attacked on the 24th of March 1998 by Serb forces, Mr. Haradinaj was seriously injured. Indeed, soldiers from Jablanica were sent to Glojan to help repel the attacks. But it was in Jablanica that he and others sought refuge. It was in Lahi Brahimai's home, away from the confrontation lines, in the relative safety of Jablanica, that he recovered from his injuries. Inevitably, as the armed conflict progressed, we say, the nature of the close cooperation between the two headquarters and the family network changed. Rustam Tetay, a former career JNA artillery officer and KLA commander, will describe the changing nature of the command structure of the KLA. He will recall going to Glojan in April 1998, shortly after the Serb attack on the Haradinaj family compound, which was in March 1998, in order to join the KLA. There he was introduced by KLA soldiers in Glojan to Ramush Haradinaj as the commander. And at this meeting with Ramush Haradinaj, also present with him was Idris Balai, introduced by Mr. Haradinaj to Mr. Tetay as Togeri or Toga, with whom Ramush Haradinaj described as a person experienced in warfare. Your Honours, Mr. Tetay will say that he was accepted as a KLA member and commander in the immediate area of the Glojan headquarters. And he describes, together with another KLA commander, Shemsuddin Chekai, the organisation of the KLA moving from village-based commands who were cooperating together to a more formal sub-zone structure under the authority of sub-zone commanders. This occurred towards the end of May 1998 at a meeting organised by Ramush Haradinaj, where both Mr. Tetay and Mr. Chekai became sub-zone commanders, as did Ramush Haradinaj himself. Another sub-zone commander will give evidence that village commanders reported to the sub-zone commanders and that Ramush Haradinaj would be in charge of the zones. What is clear is that Ramush Haradinaj was seen at this time as a person with significant influence in the area and one to whom great respect was owed within the Albanian culture. Shemsuddin Chekai preferred in the last trial to adopt Mr. Emerson's suggestion when cross-examined that it was Ramush Haradinaj that was trying to organize things in that area, and that the relationship at this time was that of Ramush Haradinaj being first among equals. Chekai stated in the course of evidence that Ramush Haradinaj was someone who was very important and enjoyed great respect. Your Honours, can I show you now, please, a map showing the division of the subzones in May 1998? It's a map that was drawn by Mr. Tetay in the last trial, and he explained, which will just give me a moment to turn it up in the book. It's page 9 in the map book. As we can in due course produce larger versions of this to make it a little bit more clearer, but if Your Honours look to the left of the map and in the area where you now know the Glojan headquarters to be, you'll see that he's drawn on the map the subdivision of that area, and you can see that they're marked 1, 2, 3 and 4. Starting at the bottom, it's a little unclear, but there is a number 1 in the middle of the circle. you can see the slightly hatched area to the right, and then if you just come into the center of the circle, you can actually see a number 1. Above that is 2, 3, and 4. Now, he explained, Mr. Tetai, that it was agreed that Ramesh Haradinaj would become the commander of Subzone 1, that he, Tetai, would be the commander of Subzone 3, and that Shamsuddin Chekai would be the commander of Subzone 2. It perhaps doesn't matter at this stage who the commander of Subzone 4 was, but you can see it was divided in May 1998 into this area. And Your Honours, this subzonal organisation continued through May 1998. And we say that Ramesh Haradinaj, and the evidence will show by looking at minutes of various meetings that were held and the testimony of witnesses who spoke about this, that Mr. Haradinaj recognised that whilst he had established formal control of the subzones around Glojan, the family ties with the Jablanica headquarters were no longer sufficient for the efficient operation of the whole zone, thus requiring the establishment of a formal structure to control the whole area. And Your Honours, we submit that in evidence that we hope will be admitted in due course in relation to what Mr. Haradinaj himself may have said about this, that by the 23rd of June, he had managed to establish control of the subzones and consolidated them to the point where he was able to unify KLA headquarters. And that had occurred by the 23rd of June and from the 23rd of May 1998. And as that developed, he then began to oversee in a more authoritative manner the activity of the Jablanica headquarters itself to balance it between Jablanica and Glojan. So essentially, midway through this indictment period, Mr. Haradinaj, the prosecution says, and the evidence will show, that he had consolidated by the end of the indictment period complete control of the two areas of the Jablanica and Glojan, and that transisted over the course of the indictment period. By the middle of the indictment, and particularly with the counts, by the middle of that period, he had consolidated control over both. And he describes in or there's a minute at least of a meeting in which he is recorded as saying, this is a meeting on the 23rd of June 1998 in Jablanica. It's on your Honour's screen now. Obviously we haven't put all of the minute there. We've just taken the relevant parts, we say. It's the 23rd of June 98 in Jablanica. We've just put the top section so you can see who it said were present. This is in E-Court 00141 at page 2. So you can see who was present, and that's translated. And then there's a handwritten part which starts Ramesh Haradinaj, and the translation shows underneath that at this meeting he was saying, in order to help one another in future, we have to supply the entire people with weapons, 16-year-olds and above. And then this, other things. We need to be positioned well, organized. Family and friendly and family connections are not enough. I can help as a friend or a relative, but I cannot make someone else do the same. And then there's a reference to territory, which I needn't trouble your honours with. It's there for completeness. Your Honours, we say this shows that there was a transition and a recognition on his part that there was a need for formal organisation to move away from what were family connections, family ties, and a more loose organisation to something that needed to function better, and that this occurred on the 23rd of June 1998. Your Honours, now turning to speak a little bit more about the accused themselves. Your Honours, I've already indicated that Mr. Haradinaj was, we say, one of the founder members of the KLA resistance movement, together with his uncle, and that as a result of the firefight that took place, and witnesses will say that as a result of that firefight that took place at his family compound, that his reputation within the area grew. They describe how KLA soldiers and the population in general regarded Ramesh Haradinaj's actions as heroic acts of defiance, effectively, and came to revere him as a commander of the zone. As one KLA member witness, Hassanai, described it, God in heaven, Ramesh on earth. As he continued his organisation of the area and consolidated his control on the 26th of May 1998, Mr. Haradinaj became leader, first of all, of the Glojan regional staff, encompassing the subzones already described, and in that capacity exercised authority over military and civilian matters. Gradually he expanded and then established for formal control on the 23rd of June, when at a meeting with the Jablanica staff, and the minutes will be adduced in evidence, Mr. Haradinaj was appointed, and I'm not sure that this is particularly in dispute, but my learned friends will indicate later, was appointed as commander of the operative staff of the Dukajin Plain, formalising his overall command of the Dukajin zone, including Jablanica, and the new formation's headquarters were based in Glojan. Lahi Brahimai, also known as Maksup, was the commander of the KLA's strategic stronghold in Jablanica during the indictment period, the prosecution says. He was also a member of the KLA General Staff as a finance director. It comes from a number of witnesses, including Zoran Stejovic and Pieter Shala and others. At the meeting of the 23rd of June, Mr. Brahimai briefly became the deputy to Mr. Haradinaj before he was replaced by Mr. Haradinaj some short while later by Nazmi Brahimai, Lahi Brahimai's brother. Idris Balai, also known as Toga, was initially recruited as a KLA training officer based in Jablanica, where he trained new KLA soldiers. Your Honours will hear evidence or receive evidence from Pieter Shala and Zoran Stejovic about that. After the 24th of March 1998 attack on the Haradinaj compound, he transferred to Jablanica from Glojan. And Your Honours, we say that indicates how the headquarters were cooperating even before the 23rd of June. On the 24th of April 1998, Mr. Haradinaj appointed Mr. Balai as the commander of the Black Eagles, a rapid reaction unit. And that comes from a number of sources, Mr. Shala, Mr. Haskai, Mr. Chekai and others. And Honours will recall that it is he who sat with Mr. Haradinaj when Rustam Tetai came to offer his experience as a former JNA officer in the Yugoslav army to develop the fighting capability of the KLA. Indeed, Mr. Balai was often seen together with Mr. Haradinaj throughout the indictment period, and a number of witnesses will testify to that. Witness 17, 80, Kabashi, 29, Papas and Stejovic. It is Tetai that speaks of Mr. Togeri as, amongst other things, a man who had a reputation for kidnapping and killing Albanian, Serbs and Roma in the Dukajin area in 1998. He also said that he had not himself witnessed these things, and that many bad things were laid at the door of Togeri. In fact, he said this: everything bad that happened was attributed to him. Doesn't mean, Your Honours, that it was done by him, I accept that, but evidence of general reputation is admissible. He confirmed, however, that Toga and his men were entering villages looking for people who were wanted, and that he had seen names written in Toga's notebook, but he did not know why they were there. He confirmed that there were lists of people circulating that had been drawn up to compromise individuals. Your Honours, it's the prosecution case that throughout the indictment period, regardless of the issue of formal control, that the accused worked closely together to advance the goals of the KLA in the Dukajin area, which included, through the commission of crimes, and at the detention facility, those crimes being committed in particular at the detention facility which had been established in Jablanica. Witnesses describe Rimash Haradinaj, Idris Balai and Lahi Ibrahimai together at Jablanica, at the place in which the detention facility was located, which was a property owned by a relative of Lahi Ibrahimai and is central to the crimes charged in this case. Your Honours, it's the prosecution case that these accused sought to establish KLA control of the zone, not just through an armed struggle against Serbian forces that they regarded as occupying powers, but also through the brutal elimination of opposition by civilians who were or were perceived to be collaborating with Serb forces or otherwise not supporting the KLA, regardless to be whether they were Serb, Roma, Egyptian Ashkali or Kosovo Albanian. They thus pursued a common criminal purpose which involved commissions of crimes against persons perceived to be spies and collaborators with Serbia or Serb forces, or otherwise considered not to be supporting the KLA. Members of the KLA abducted, interrogated and mistreated those persons, often murdered them. And this acts of violence created an atmosphere of fear and intimidation within the population of the Dukacin zone and elsewhere in Kosovo where the KLA was operating. Your Honour, within the free area described by the witnesses I've already addressed, away from the immediate confrontation lines, the KLA were able to act more openly. As Shamsuddin Chekai put it, along the main road, Peja to Dechani to Jakova, the villages that were close to the road were at risk, and the KLA soldiers were positioned there, in those villages, while in the internal parts they could carry out other duties, secondary duties, or be with their families. So the situation was like that they also carried out other duties, family duties, or other personal business. And as we say that with that greater freedom, the KLA and these accused could consolidate their control of the area through the rooting out of opposition, whether it be Serbs, Albanians, or other ethnicities, and those suspected of collaboration or treachery in any way were targeted. Indeed, from 1994, the KLA had publicly claimed responsibility for murders and other attacks against collaborators and others not supporting the KLA through its communiques, which have been put into the evidential bundle of the 65 TER lists, and to the KLA communiques to the Kosovo, Albanian and Serb populations published in the media between 1994 and 1998. For example, on the 11th of December 1997, the KLA introduced itself in its communique number 40 by announcing that it had turned, quote, the barrel of a gun against the invader and traitors. Well, that's comes within the 65 TER numbers of 00953, 00931, 00340, pages 3324 to 3325. Throughout 1998, the KLA announced and claimed responsibility for attacks and punitive measures against collaborators. And they claimed responsibility for attacks against Serbian police. On the 4th of March 1998, the KLA General Staff publicly declared death to enemies and traitors. That comes from Jakub Krajniki, 00328, page 37, and elsewhere. The threatening language of the communiques, we say, leaves no room for doubt as to what will happen to those suspected of collaborating. In its communique number 42, it declares that on 13 February 1990, but given the context, John, that must be 1998, Mustafa Kurti, a collaborator with the occupier, was liquidated. And immediately underneath, on 19 February 1998, the criminal Nebojša Cvecic, a member of the Serbian police force, was liquidated at Luzan near Podijevo. In a communique in December 1997, the KLA declared, on the evening of 28 November 1997, Dalip Dugoli, a collaborator and one of Milosevic's most trusted men, was killed. And in its communique number 39 from November 1997, the KLA declared, quote, "The Albanian nation abhors the aggressor and its terrorism. It detests and despises traitors and betrayal that jeopardize and risk the fate of our liberation war," end quote. Your Honours, it's clear that the targeting and elimination of collaborators was threatened and encouraged from the earliest beginnings of the KLA. And it's also clear that this aim continued into 1998. In particular, the KLA issued a further communique, number 47, from Pristina on the 12th of May 1998, and published in Pristina in the Kohaditori newspaper in Albanian on the 13th of May 1998, in which the KLA declared, Your Honours have there the document, which is in E-Court 00328, and then we've taken the part that we are wishing you to look at. And in there it says, on the orders of the Uchikal KLA General Staff, successive operations against invasion troops were carried out in Operational Zone Number 1, that is the operational subzones of Drenica, Erenik, Dukajin, Pastrik and Lap. In the course of bitter fighting on the front, the invading forces suffered major human and material losses. Throughout this period, operations were also carried out against Albanian collaborationists who, despite earlier warnings, did not abandon their anti-national courses of action, end quote. Your Honours, in addition, contemporaneous Serb Security Service and police reports, and I am conscious of what Mr. Emerson said yesterday about those documents and the source and content of them, but nevertheless, Mr. Stejovic and other Serb police witnesses produce a large number of reports for what they are worth, in which there are complaints of violence and intimidation by members of the KLA and against those not supporting them or deemed spies and collaborators.
If I may just interrupt you, would that be a convenient time to take a break?
Your Honours, may I have 5 minutes, and then it will be, because I'll be turning to the counts. It may not even be 5 minutes. Your Honours, the fact such targeting was carried out in the Dukajin zone in July 1998 is borne out in the evidence of witness 17. He described being given a list in July 1998 by the KLA commander of the Baron Valley area, Din Krajniki, who the prosecution says had been appointed by Ramush Haradinaj. We'll get that from the evidence of Mr. Hassanai. And on that list were a number of wanted persons, some variously described as collaborators. Amongst those on that list were Zenun Gashi, who was also abducted by the KLA and whose body was later recovered, among others, at the Radonic Lake. And there will be evidence relating to his abduction and death in this case. And also on that list was Skendakuchi, who is a named victim in count 5. He was seen at Jablanica, and there he was beaten and tortured and ultimately murdered whilst in KLA custody. Your Honours, in the context of this conflict, which also involved the legal use of force, the prosecution says these accused adopted illegal means to achieve their goal of control. Those illegal means are described in the indictment, and they form the subject of the 6 counts, which I'll be turning to very shortly. And it's through the adoption of those illegal means that the accused became part of a joint criminal enterprise. Indeed, they worked together to torture, cruelly treat, and murder those considered traitors to the KLA cause. Each of the accused shared the intent to murder, cruelly treat, and torture the victims. Haradinaj, Balai, Brahimaj, other KLA soldiers, including other members of the Brahimaj family, worked together to suppress and eliminate perceived opponents through murder, cruel treatment, and torture committed at the detention facility in the KLA barracks in Jablanica. And Your Honours, the crimes to which I will now turn are examples of the suppression and elimination of the perceived opposition by the KLA. And Your Honours, that is, I hope, a convenient moment.
very much, Mr. Rogers. We'll take a break and come back at 4 o'clock. Court adjourned.
All rise. Faithfully be.